Councillor Johnson, good morning.
How you doing, gentlemen?
What do you know of today's ruling?
Well, today's ruling, we know that the judge has scrapped onto himself an authority that he doesn't have. When specific provisions of the Constitution are raised as subject matter of discussion in a trial, a court of limited jurisdiction, specifically a trial court, does not have the authority to interpret the Constitution. That authority is ascribed to the full bench of the Honorable Supreme Court. To date, the judge had indeed agreed that the former officials of government are immune from any criminal prosecution or judicial inquiry for acts committed or acts carried out while serving as members and statutory members of the National Security Council and principal advisors and agents of the presidency. That immunity of the president that extends to the advisors of the president and the agent, that immunity can never be subjected to judicial review in a court of law. The courts shall refrain from conducting inquiry on the basis that any attempt will compromise national security. In fact, it's on the other way around. Why we should be protecting the protection of national secrecy, I see the government proceeding to expose national security operations, especially about expenditure during elections to keep this country safe from threats to the elections.
Also, if you agree that the judge ruled against you, if you agree that the judge in his ruling admitted that it was right for them, why did he rule against you and then he took an exception to the Supreme Court?
Is that with the wisdom of the judge? The next thing is the defendants, the former ministers of the former officials of government cannot stand trial. Why? Under the due process clause that we have in fact our cases like the Wallow versus Wallow, the landmark case on due process, before you are convicted, you have the right to question the witnesses, to produce evidence in your favor in order to exonerate yourself. These officials are prohibited by law not to defend themselves. And what is the law? The National Security and Reform Act, Intelligence Act of 2011 says, as long as they are alive until 20 years, even if they go for trial and they take the witness to testify about how they expended the money, when they come outside, the NSA will arrest them also because they have breached national security intelligence operations. That's why you take off on the level at the level of the National Security Council.
So, in short, Council, are you saying that the judge erred in his ruling against you people?
The judge erred. And in fact, the ruling went beyond the scope of authority of the court.
Meaning that you are taking flight to the Supreme Court for your account?
Well, the team will discuss that. But what we know is that the law already gives us the authority to go on the remedial process when the judge had made a decision, especially on the issue of authority, that he had gone beyond his authority. The judge, the trial court, has no authority. And that is a standard established by the Honorable Supreme Court by years of horror with age, that whenever constitutional issues are squarely raised, no court of law has the authority to determine and pass unconstitutional arguments beside the full bench of the Supreme Court.
The judge did quote Article 51 of the 1986 Constitution as it relates to people being immune and exempted.
Under Article 61 that talks about immunity of the president.
61.
No, it's 61. It's 61.
And not 51.
It's not 51, it's 61. Under Article 61 of the Constitution, the president is immune from all prosecutions. The only time the president is not immune from prosecution, it must be certified by condition precedent. What are those conditions precedents? The condition precedents are the president must first be impeached and removed. Any leader in this country who has never been impeached and removed, every act or acts that he conducted or carried out or he assigned to his agents while serving as president, that extension of immunity covers them, and you cannot question those agents. This is the argument before the Supreme Court that will soon be appearing. Whether or not an agent or an advisor of the president serving at the level of the National Security Council, which they are creating the National Security Council, prohibits him that you cannot take the stand to testify on national security matters that have not been declassified. As we speak, the expenditure of the former government to maintain a peaceful transition, to divert and abort the threats to national security and the elections of 2023, The government presently had never declassified that information. Any of these officials who comes to court and to testify how that money was expended, who the agent that received it, and what area they assigned the agents for what purpose, they will go to jail. So you see the dilemma that our clients have. So we are saying this is a serious landmark argument